Hello again, and thank you for joining me for another episode of You Would Think. So we have come to the end of the Lindsay Clancy trial. Today is day 22, and they are getting their jury instructions, which we'll go over, and also the closing arguments from the defense and the prosecution. First, full disclosure, I am not an attorney. I do not have a law degree. My degree is in forensics and crime scene technology. Watching trials and true crime cases has been a bit of a hobby of mine. So I thought I can make a YouTube channel so that I can talk to other people who like the same things, and we can talk about different trials, talk about different things, and kind of just engage. Plus I can get your perspective on certain cases as well. All right, well, we'll start with the jury instructions. The judge broke them out into two different phases. First phase, he gives them some information about how closing arguments will go, and what additional information that they are able to consider and towards the charges. And then after the closing arguments, then he will come back and instruct them on, what they can consider for the charges themselves, which at this point seems to stand at they can consider first-degree murder, which is premeditated, second-degree manslaughter, which is crime occurred while the individual was under extreme emotional disturbance. There is a not guilty by way of mental disease or defect. And there's also whether or not they find her criminally responsible, as it is stated in the law in Massachusetts. And remember, there's the two pieces of that you have to be able to prove. One is, could the individual control their conduct? And two, did they have the capacity to appreciate the wrongfulness of what they were doing? He instructs them on the specific indictments against Ms. Clancy, so the charges, and we can listen to a bit of that.
Well, the arguments in charge, all right, and that just means I'm going to give the charge as my instructions, all right. I'm going to instruct you on the law that you are to apply in this case to the facts that you're going to find, and then the argument part is we're going to hear the closing arguments from the attorneys. And the way we do it, the way I do it, is I kind of split it up. So I'm going to give you first half of my instructions. We'll talk a little bit about the specific charges in this case. And then after the closing arguments, I'll come back and give you some more general instructions about how you, the burdens of proof and how you are to go forward and do your deliberations and handle the deliberations. All right. So they take a while. All right. They can be, well, they can't, I was going to say rather dry, but they are dry. And so what the parties and myself have agreed to do is I'm going to we printed out the instructions that I'm going to read to you. So you'll have those with you, all right, as we go through this morning. And so some people find that helpful to read along and comprehend. Some people don't. So if it's distraction, you don't have to read it. But some people find it helpful, so we thought we'd do that. You also should know that you'll have these instructions. You can bring these with you in the deliberations. So you'll have this whole outline of what the law is so that you are to apply. All right? So at this point, if we could hand out the copies of the instructions. Oh, you already have those? Oh, geez. I forget how efficient our court officers here are. So what I'm going to do is I'm going to start the instructions now. All right? So my instructions on the law are going to be delivered to you in two phases. As I said, first, I'm going to instruct you on the specific indictments that have been brought against Ms. Clancy. After I conclude my instructions regarding the charges, the Assistant District Attorney, Ms. Sprague, and Attorney Reddington will each deliver their closing argument. Remember, the arguments of counsel are not themselves evidence. They're provided to assist you in organizing and understanding the evidence that's been presented during the trial and the conclusions that each party would like you to draw from that evidence. At the conclusion of the attorney's closing arguments, I'll give you the second part of my jury instructions. And in that phase, I will give you go over a number of very important principles that will guide your overall evaluation of the evidence, your deliberations, and your eventual verdicts. The instructions are to be taken and considered in whole. All right, so the first and second part are equally important. So you to consider all of my instructions as a whole. You'll notice, as I said, I'm reading these instructions to you. Excuse me. I apologize for doing that, but I have to give these instructions clearly and accurately. So as I said, to assist you in your deliberations, I provided you with written copies of these instructions. However, those written instructions are not a substitute for the oral instructions I'm giving now. So please listen carefully. All of my instructions are equally important. You're not to overemphasize one portion of these instructions or ignore other portions. These charges have specific factual elements that the Commonwealth must establish.
He does reiterate with them that any of the arguments made during closing arguments are not to be considered as evidence. Then he goes over some important principles to consider that will help guide them through their deliberations. And that there are certain factual bases that the Commonwealth have to prove beyond a reasonable doubt in order for them to be able to factually hold Ms. Clancy criminally responsible for her actions. They are to understand that in America, a person is innocent until proven guilty, and everyone should be afforded that right. He says that, being criminally responsible is a legal term. And if it's found that she is not criminally responsible by way of mental disease or defect, they could petition the court to commit her to a mental health facility. And if the court deems her to be mentally ill and that her discharge would cause substantial risk of harm to herself or others, that she would be committed to the mental health facility, and periodically the courts would review that order. And if the court determines that she's still suffering from a mental illness and dangerous, that she could be ordered to be committed for the rest of her life. There's no limit to how long. He also explains how the district attorney's office has the right to be notified and present and speak at each hearing where they are reevaluating her if she is found to have a mental disease or defect. In Massachusetts, the jury decides if it is first or second degree murder. Remember, first is premeditated. And if they cannot agree, because it has to be unanimous. So if they cannot agree on first degree, then they can consider second degree. And if they can't come to a decision on second degree, then they can consider manslaughter. And it will just kind of keep going down the list.
Remember that the law presumes the defendant to be innocent of the charges against her. This presumption of innocence is a rule of law that compels you to find the defendant not guilty unless and until the Commonwealth produces evidence from whatever source that proves that the defendant is guilty beyond a reasonable doubt. So now I want to go into the instructions that are specific to this case. First, I'm going to have a drink of water. Thank you. Now, in this case, Ms. Clancy is charged with 3 counts of murder. I want to talk first about the issue of criminal responsibility. All right. Now, to prove the defendant guilty of any crime, the Commonwealth must first prove beyond a reasonable doubt that the defendant was criminally responsible at the time the alleged crime was committed. The Commonwealth bears the burden of proving beyond a reasonable doubt that the defendant committed the crime with which she is charged, and also that the defendant is criminally responsible for her conduct. The defendant has no burden to prove a lack of criminal responsibility. Criminal responsibility is a legal term. A person is not criminally responsible for her conduct if she has a mental disease or defect, and as a result of that mental disease or defect, she lacks the substantial capacity either to appreciate the criminality or wrongfulness of her conduct or to conform her conduct to the requirements of the law. The phrase mental disease or defect is a legal term, not a medical term. It need not fit into a formal medical diagnosis. The phrase mental disease or defect does not include any abnormality characterized only by repeated criminal conduct. It is for you to determine, in light of all the evidence, whether the defendant had a mental disease or defect. If the Commonwealth has proved to you beyond a reasonable doubt that the defendant was not suffering from a mental disease or defect at the time of the killing, the Commonwealth has satisfied its burden of proving that the defendant was criminally responsible. If the Commonwealth has not proved to you beyond a reasonable doubt that the defendant was not suffering from a mental disease or defect at the time of the killing, then you must consider whether, as a result of a mental disease or defect, the defendant lacked the substantial capacity either to appreciate the criminality or wrongfulness of her conduct or to conform her conduct to the requirements of the law. To establish that the defendant had the substantial capacity to conform her conduct to the requirements of the law, the Commonwealth must prove beyond a reasonable doubt that any mental disease or defect that may have existed did not deprive the defendant of her ability to behave as the law requires, that is, to obey the law. The word appreciate means to understand rather than merely to know. Criminality means the legal significance of conduct. Wrongfulness means the moral significance. The Commonwealth must prove that the defendant knew and understood that her conduct was illegal or that it was wrong. It's not enough for the Commonwealth to show that the defendant merely knew or was intellectually aware that her conduct was illegal or wrong. Rather, the Commonwealth must prove beyond a reasonable doubt that a mental disease or defect did not deprive the defendant of a meaningful understanding of the legal or moral significance of her conduct. The defendant must have been able to realize in some meaningful way that her conduct was illegal or wrong. In considering whether the Commonwealth has met its burden of proof, you may consider all the evidence that's been presented at this trial. You may consider the facts underlying the crime and evidence of the defendant's actions before and after the crime. You may consider the opinions of any experts who testified and give those opinions whatever weight you think they deserve. Now, in a moment, I'll instruct you on the elements of the offense that the Commonwealth alleges that the defendant has committed. Remember that the Commonwealth must prove to you beyond a reasonable doubt that the defendant was criminally responsible at the time that the crime was committed. That is, that the defendant did not lack criminal responsibility at that time. Therefore, it is the Commonwealth's burden to prove at least one of the following beyond a reasonable doubt. One, that at the time of the alleged crime, the defendant did not suffer from a mental disease or defect, or 2, that if the defendant did suffer from a mental disease or defect, she nonetheless retained the substantial capacity to appreciate the wrongfulness or criminality of her conduct and to conform her conduct to the requirements of the law. Now, as I have previously instructed you, your decision should be based solely on the evidence and the law of this case. If a defendant is found not guilty by reason of lack of criminal responsibility, the district attorney or another appropriate authority may, and generally does, petition the court to commit the defendant to a mental health facility or to Bridgewater State Hospital. If the court concludes that the defendant is mentally ill and that her discharge would create a substantial likelihood of serious harm to herself or others, then the court will grant the petition and commit the defendant to a proper mental health facility or to Bridgewater State Hospital. Periodically, the court reviews the order of commitment. If the defendant is still suffering from mental disease or defect and is still dangerous, then the court will order the defendant to continue to be committed to the mental health facility or to Bridgewater State Hospital. There is no limit to the number of such renewed orders of commitment as long as the defendant continues to be mentally ill and dangerous. If these conditions do continue, the defendant may remain committed for the duration of her life. If at some point the defendant is no longer mentally ill and dangerous, the court will order her discharged from the mental health facility or from Bridgewater State Hospital after a hearing. The district attorney must be notified of any hearing concerning whether the person may be released, and the district attorney may be heard at any such hearing. However, the final decision on whether to recommit or release the defendant is always made by the court. Now, I'm going to go over at this point the specific elements of the charges against Ms. Clancy. So I want to talk first about murder in the first degree. The defendant is charged with 3 separate indictments charging murder, 1 count each relating to Cora Clancy, Dawson Clancy, and Callan Clancy. The instructions I'm going to give now apply to each separate indictment relating to each child. There are 2 different degrees of murder. There's murder in the first degree and there's murder in the second degree. If you find the defendant guilty of murder, you shall decide the degree of murder. The Commonwealth alleges that the defendant committed murder in the first degree on the following theories. First, that it was murder with deliberate premeditation, and then second, and or it was murder with extreme atrocity or cruelty. To find the defendant guilty on any of these theories of murder, you must be unanimous. That is, all of the deliberating jurors must agree that the Commonwealth has met its burden of proving every required element of that theory beyond a reasonable doubt. You should check the appropriate box or boxes on the verdict slip as to each theory of which you agree unanimously. And I'll go over a little bit later the verdict slip and how that is going to be handled. Now, so if you're unable to agree unanimously that the Commonwealth has met its burden to prove beyond a reasonable doubt either of these theories of first-degree murder, you shall consider whether the Commonwealth has proved the defendant guilty beyond a reasonable doubt of murder in the second degree. So I'm going to begin by instructing you on the elements and the additional requirements of proof for each of these theories of murder in the first degree. And then I'll instruct you on murder in the second degree. All right. So number 1, I'll first define the elements of murder in the first degree with deliberate premeditation. To prove the defendant guilty of murder in the first degree with deliberate premeditation, the Commonwealth must prove beyond a reasonable doubt the following elements. 1, the defendant caused the death of Cora Clancy, Dawson Clancy, and or Callan Clancy. 2, the defendant intended to kill Cora Clancy, Dawson Clancy, and or Callan Clancy. That is, the defendant consciously and purposefully intended to cause Cora Clancy's, Dawson Clancy's, and or Callan Clancy's death. And 3, that the defendant committed the killing with deliberate premeditation. That is, she decided to kill after a period of reflection.
First, the defense is going to do their closing arguments, and that will be in a separate video. After the closing arguments concluded, he came back and began to explain the second phase of the instruction to them. He clarifies that in the reading that the second degree, they have to prove an element of intent, but they are allowed to consider her mental state when deciding on second degree. They're also able to consider the post-incident behavior, so ways that she acted after the crime occurred. They are allowed to consider that behavior, but also cautioned that a consciousness of guilt is not enough on its own to find somebody criminally responsible for their actions. And then he closes out with, explaining to the jury how important their job is and how sacred and how, this is how our criminal justice system functions, and that they should put aside any speculation, emotions, bias, anything of that nature, and solely be able to focus on and consider the evidence that was presented in court by either way of actual evidence or an expert's testimony or anyone else's testimony.
I just kind of want to make sure that something's clear. So I'm going to ask you to go back to page 6. I think we were talking about murder in the second degree. Everybody get there. All right. And what I just kind of wanted to make clear, that you may consider the defendant's mental condition at the time of the killing, including any credible evidence of mental impairment or the effect on the defendant of her consumption of prescription drugs, in determining any of the elements in the murder in the second degree charge as well. I mentioned that for some of the others, but and specifically for the charge in murder of the second degree, there's an element regarding intent. Okay, so I just kind of wanted to make that clear. Probably is suggested in that, but as I read through it, I just kind of wanted to remind you that you can, as I said, you can consider the defendant's mental condition at the time of the killing, including any credible evidence of mental impairment or the effect on the defendant of her consumption of prescription drugs, in determining the elements in murder in the second degree. All right. So I hope that cleared things up rather than confusing you any. But now I'm going to go to the general principles in regards to this case. All right. Now, as I said to you before, I'm incorporating the instructions that I gave earlier before the closing arguments with these instructions. So I want to talk about the presumption of innocence and the burden of proof. Once again, the indictments against Ms. Clancy are only an accusation. They're not evidence. The defendant has denied that she's guilty of the crimes charged in these indictments. The law presumes the defendant to be innocent of the charges against her. This presumption of innocence is a rule of law that compels you to find the defendant not guilty unless and until the Commonwealth produces evidence from whatever source that proves that the defendant is guilty beyond a reasonable. Some evidence suggesting the defendant's actions after the killings. I'm not suggesting that these are the facts, because the facts are your exclusive domain. But there is some evidence to that effect, and I mention it here to describe the legal point that's implicated. If the Commonwealth has proven that a defendant did any of these things, you may consider whether such actions indicate feelings or consciousness of guilt by the defendant, and whether in turn such feelings of guilt might tend to show the defendant's actual guilt of the offenses with which he's been charged. You are not, however, required to draw such inferences, and you should not do so unless they appear to be reasonable in light of all the circumstances in this case. If you decide that such inferences are reasonable, it will be up to you to determine how much importance to give them. But you should always remember that there may be numerous reasons why a person not responsible for the crimes charged might do the things attributed to her. Such conduct does not necessarily reflect feelings or consciousness of guilt. So please bear in mind that a person having feelings of guilt is not necessarily guilty. In fact, for such feelings are sometimes found in innocent people. So finally, remember that standing alone, consciousness of guilt evidence, if you find there was any, is never enough by itself to convict a person of a crime. You may not find the defendant guilty on such evidence alone, but you may consider it in your deliberations along with all the other evidence that was presented at the trial.
So that was the end of the jury instructions. Thank you again for joining me for this short but important episode of You Would Think. Please put all of your comments in the comment section so that I may address them. And otherwise, if you enjoyed the content, please like and subscribe so I can bring you more of it. And I will see you again in the next video, which is going to cover the defense and the Commonwealth's closing arguments.